with Raph Epstein. Get yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is here to give you free legal advice. We'll also roll out the detail as we get it about the state government's response. No second supervised injecting room, but there will be an expanded pharmacotherapy service coming out of that building, which is actually opposite Flinders Street Station, the old Uralla building. We'll get to that detail. But David Whiting, good morning.
Good morning, Raph.
No homework?
No, got the week off. Did nothing. Slept in, did the lot.
Beautiful. Read books, caught up on all those TV shows. So let's give some legal advice, beginning with Eric, who is in Croydon. Eric, what's your query?
Well, thanks very much for your time. My query is on building deposits. Previously, a builder would take a 10% deposit on a job worth $20,000.
Yes.
So I've had a plumber yesterday for a $5,000 job, wants to charge me 50% before he starts. Is it legal to charge 50% of a job before?
Can I say it is legal? And it may well be that that's the cost of the materials in the job.
Yeah.
So, if someone's getting some fittings in a bathroom, $2,500 doesn't go very far. So that could be what it's for. In terms of the building contract, there are rules relating to deposits and progress payments under a domestic building contract. So that probably limits the builder asking for more than 10%.
Yeah. Okay, thanks for that. I was just surprised, and I also had a couple of neighbours where the builder or the plumber has done a runner on them with the 50% paid.
Oh, well then ask for if you like, for a reference. Can you give me someone else who you've done work for? But have an idea about what the cost of the materials is, and that might give you a better indication of the reasonableness.
Good luck, Eric. Thank you. Christine is in Blackburn. What's your query, Christine?
Oh, hello, David. Thank you. We've been renting this place for 4 years. We've just signed a new contract in January for a 12-month lease. Our landlord has now come back to us and said he wants to move back into the home, and we have to find somewhere else to live. And he wants to do it very quickly, and we don't have anywhere to go. Where do we stand legally, please?
The honest answer to your question, Christine, is that I don't know. And that's because it was always my assumption that if you signed a 12-year lease, then someone couldn't arbitrarily bring it to an end. There's certainly from the tenant's perspective the possibility of making an application to VCAT saying there are changed circumstances. My view is you're probably entitled to stay where you are. And there is a notice period where they want to move back in. Have they complied with the notice obligations?
No.
Well, if they haven't complied, there are specific notice obligations. I was looking at this the other day. I think it's Section 61ZZO of the Residential Tenancies Act. And if you look at the VCAT website, no, not the VCAT, if you looked at the Consumer Affairs website, if the landlord says, I want to move in, then there are a series of specific things they need to give you with the application. Otherwise, the notice they've served is not valid.
Thank you very much.
So you can ignore it. So look at Consumer Affairs. It will tell you what needs to come with a I want to move back into my house application. And one of the things I'd want to know is make sure that the property is actually in the landlord's name. If it's in a company, then it's a whole new ballgame.
And just for clarity, if Christine wanted to proceed with some sort of court issue, or the landlord did, would that go straight to VCAT or does that go to court?
It goes to VCAT.
It would go to VCAT.
Residential tenancies.
So 100% goes to
that
territory.
Yeah.
Okay, which is exactly the sort of things we are going to be talking about in May.
Yes.
Okay. First up, Pat's in Yakandanda. What's your query, Pat?
Raph and David, I went to the International Garden Show. My wife and I went down, and we went to the behind the exhibition buildings. We went to the ticket sales office. The price of the ticket was listed as $32. When we went to pay, they charged us a $2.08 booking fee, and it didn't matter whether we were going to use cash or whether we wanted to pay by card. I just wondered, is that I mean, the listed price was $32, but yet in fact it's $34.08. So I just wonder
do I object to it? The answer is yes. It's the fee. It's the passing on of the fee that for the software that manages the ticketing process. So it should say plus booking fee.
Yes.
And you did book. You booked the instant before you wanted to enter the flower show.
All right. Well, David, thank you very much for that.
Next time we'll make sure they say and booking fee.
All right.
Okay.
Thank you for your time.
Good luck. And Tom has called from Meetown with a question for David Whiting, our talkback lawyer. Go for it, Tom. Oops, sorry, Tom. My fault. Go for it.
Oh, thank you. Good morning. Thank you for taking my call. Recently, my mother passed away, and she was known all her life by her middle name. And it was only recently, after my father passed away about 14 years ago, that she was then identified by her first name and middle name, but then also on the will document was also known as her middle name.
Yes.
And her surname. Yep. Now, on her death certificate, we have her middle name and her surname, and also known as her full name, which is her first name, middle and last name.
Yep.
Our solicitors doing probate feels that that's a bit of a concern and is going for a new death certificate. Would that be appropriate?
Are there any? Your mother had some assets. Were they in a name that? What name were they in? The absolutely archaic correct one or the new one?
Well, a little bit of both.
Then you make an application for a grant of probate for Mary Smith, also known as Joan Smith. It's just that simple.
Right.
All right.
But that's sort of...
And the reason what the probate office only cares, and you really only need to care, if there are assets in both names that you need to deal with. So what you're trying to do is use the probate document to link the legal name from the death certificate with the name on the assets you want to deal with. So if you were to make an application for a grant for Violet Jones and find that the bank account is in the name of Mary Jones, then you've got one hell of a hurdle to deal with. That's why you do it.
Right.
Yes.
Okay.
But altered probate document, not death certificate.
Yeah, and if you're interested in why is the death certificate wrong, it's somebody told the undertaker the wrong thing.
Well, she did ask us, and we did say she suggested that it should be everything that's shown on.
Oh no, it should be. But when you walk into the undertaker, they first thing you say is, "What's the full name? Are you known as anything else?" Well, not you, because that person is the one we're talking about.
Yes.
But yeah, you get the idea. So that's what you need, Tom. I don't think you need a new death certificate, but there may be something in particular in relation to the issue that warrants it. About once a year, I write to births, deaths and marriages and say, you've been given some wrong information on a death certificate. It ought to say this and this is why. So it's interesting.
Thank you very much, Tom, and good luck with that as well. Michael, you're in Wonthaggi. What's your query?
Yes, good morning. Thanks, David. My wife had a fall outside of Spencer Street Station. And
Michael, you're old. It's called Southern Cross now.
Well, whatever.
Yep.
I am old.
Yeah.
And it was caused by a small piece of polypipe, which was protruding from the base of a steel pole. And she did a face plant in the footpath and caused quite some damage to her teeth.
Michael, your claim is against the person who did the bodgy work. Now, that might be contractors for the City of Melbourne. It might be contractors for the station. You need to sort of work that out. So make a report, maybe make a claim on the City of Melbourne, and they'll tell you if it's not them. Okay. There are protections for road-making authorities, but this is clearly not deterioration but the doing of inadequate work.
Right, okay. I think it was a camera pole, steel camera pole, right in the middle of the footpath.
Well, it may be that whoever installs the camera, be Department of Transport, I imagine, or Justice, have come along and they've put it in but haven't finished the process, haven't finished it off, then you have a claim against them for the work they've done.
Okay, and how would I find out that the City of Melbourne would notify me?
Well, I would be going to the City of Melbourne on the basis that it's their road, it's some wonky work on their road. They'll very clearly tell you if it's not them, and they might indicate who it is. But if you go, I know you're in Wonthaggi, so it's a bit hard to look, but if you've got someone who can go and look and take some photos and see if the site's changed, that might help you identify who did the work.
Good luck, Michael. Thank you for your query. Phil is in Wodonga. What do you want to ask, Phil?
Hi, long-time listener and absorbing your wisdom. My stepchildren's biological father passed away really unexpectedly a couple of months ago. Now, the kids were contacted by his super fund to see whether they wanted to be accepted as getting some of the money, which the three children, which are all adult children now, all said they would be. And then they were contacted 5 days later by email again to say that the super fund had decided to grant 100% of the money to their father's partner and not give them anything.
Yeah.
So I was wondering, they must have been beneficiaries or must have been listed in the super because they were contacted in the first place.
Sorry, let's divide this up. Lots of people have self-managed superannuation funds. Review rights don't exist for a self-managed super fund. But if
it's
you're...
not self-managed, it was
it's a public fund.
Super fund.
It's a public fund, all right? In a public fund, you have the right, your stepchildren, because it was their father who died, have the ability to dispute the decision made by the super fund.
Okay.
All right? So they go to the super fund. If the super fund says too late, you talk to AFCA, afca.org.au.
Okie dokie. All right, no problem at all. Do we need lawyers to do the application?
Not to start the process. You don't. You might if you start getting in long, protracted negotiations, but your view would be the super fund has the obligation to consider the beneficiaries, and it may well be that the partner who they've given the benefit to, it might be overall more just that she gets it than the kids, but I don't know.
Yep.
So it's a question of weighing.
Good luck, Phil. Interesting one. 1300 222 774 is the phone number if you'd like some legal advice with David Whiting. We will go over the 10:30 news headlines to make sure you get your full measure of what Phil called David Whiting's wisdom, which we can all agree is wisdom. Harry is in Clarkfield. Harry, what do you want to ask?
Yeah, g'day. Thanks for taking the call. It's a Section 173 amendment application as part of a two-lot subdivision.
Yes.
In short, what happened was everything was done, all the applications were made and so on and so forth. It was knocked back and then it went to VCAT, and at the VCAT hearing, they threw it out on the basis of no jurisdiction. And after a lot of looking through the Planning and Environmental Act, it seems that if the council does not give in principle agreement, then you have no right of appeal. Yep. And that's the end of it. Okay. Is that, I'm sort of clutching at straws because I've tried everything since last November, and given it's the council election year, I thought with the councillors coming out of hibernation, there might be a chance to petition them.
Okay. Harry, the Section 173 of the Planning and Environment Act is an extra planning control that exists beyond the planning scheme. So, for example, it might be, yes, I'll give you a planning permit to subdivide, but only if you leave that house there, or only if you plant trees or build a road or those sorts of things. And they are obligations that bind an owner for a long time to come. Basically until the council says they don't. And if you're not happy with the council's response to your Section 173 agreement, you've got nowhere to go. You've got nowhere to VCAT, because it's not an appeal to VCAT against a planning decision. It's I want council to renegotiate a contract, and they won't.
It's like trying to get the law changed.
It's kind of, well, yeah, it might be. So if you think about every now and then you'll see a large parcel, say 100 acres, and someone's cut off a house block. And they might, years ago, have given you a permit to cut off the house block, but you've got to promise not to further subdivide the 99 acres. Well, it's possible that in Clarkfield that might be Harry's kind of issue, and he now says, well, the world's changed since that deal was done. I'd like to do it again. Matter. And the answer would be no. I'm trying to deal with an adjoining shire, Harry, so I know your problem.
Sorry, Harry.
Okay, thank you.
Good luck. Joy is in Greenvale. Joy, what's your query?
Morning, David and Raph. David, I ordered a room full of new curtains from a very large store that everybody does know. They wanted 50% deposit on the day. So
they must have been talking to Eric from Croydon.
Yes,
who
I
had the
think
same
they
problem.
were
Yep.
actually, yes. And though there were delays with the fabric, it went on and on. Then I get a message that they want the full price now before they will even make an installation date for me. So I had to pay the other half.
Yes.
And that was a couple of weeks ago. Made the appointment for installation. It was being put off again for another couple of days. Is this legal for them to demand all of this money from me when I haven't even got a thing?
Well, I have sympathy for the first deposit because they needed to apply the material, cut it to length, cut it to width, trim it, do all of those things. So I can understand the request at that point. I'm amazed that they wanted payment in full before installation, but that might be simply the way they do business. What you ought to do is go back and require that they be installed by a particular time, or you could go to VCAT and say, I want my money back.
Okay. All
so
right,
put some pressure on them to for a commitment as to installation, otherwise you're off to VCAT.
Thank you, David.
Good
Thank
luck.
you. But it seems to be legal what they've demanded from
It's
me.
not illegal. No, it's not against the law. There's no law that says they can. There's no law that says they can't.
Thank you, David. That's what I wanted. Thank you.
Okay, good luck, Joy. I hope the curtains are good. I hope you get them in the end. Tony is in Yay. Tony, go for it.
Good morning, David.
Morning. Could you speak up just a little, Tony?
Yes, certainly.
Thank you.
I put a sizable deposit on a portable kit home on the basis that this company had an enforceable undertaking in place from Consumer Affairs.
Yes.
3 months later, with no sign of the refund coming through and deeds of settlement being proposed.
Let's go back a bit. You entered into a contract with them to provide a house. You paid them some money.
That's correct.
And
Yes.
and Consumer Affairs got them to agree to give you your money back. Is that about right?
Not quite. Consumer Affairs had an enforceable undertaking for previous clients, and the fact that this enforceable undertaking existed was used to promote and market the kit home, and it was absolutely guaranteed that any monies I put in would be refunded.
Wow. It's like saying, oh, here's evidence I've been naughty before, so you know I'm going to be good now.
Ironically, yes.
Yes, okay.
So I'm now at the point where, I'm talking to his lawyer, and it looks like Consumer Affairs can actually do nothing, and VCAT's the next step. Would you agree?
I would agree.
Okay.
Join the
VCAT
queue,
and then
Tony.
Magistrates Court, etc., etc.
Okay. Well, you could go to either, but if you go to VCAT, and you'll get a faster answer at in the Magistrates Court. Well, is the company you're dealing with Victorian-based?
Yes, it is.
Okay, because if it was interstate-based, you would need to go to the Magistrates Court. Your costs will be cheaper in the long run at VCAT than they will be in the Magistrates Court.
Well, I suspect based on the history, it's going to take both.
No, it won't. Thank you, Tony.
No?
No.
Okay, thank you.
Thanks a lot, Tony. Good luck. Fiona is calling from Brunswick. Fiona, what's your query?
Hi, I was just wondering, can council increase my rates when there's a building order on the property?
Yes.
Basically, yes, they can.
What happens for council valuations are adopted by council in July based on the council's estimate of the value of your property in January.
Yes, but still, the building order's been in place, and I was looking at Section 5A, which was supposed to take into the evidence of sales of comparable sales, whereas properties in this have not increased. And then looking at 5A 3B, which was the effect of any act, regulation, local law and planning scheme or any other such instrument which affects or may affect the use of development of such
Fiona,
land.
I think you're out of time to deal with the current year rates. You'll be way outside your review time.
I'm in contact with the Valuer General already. It's just more that asked for more evidence as to why, but they seem open to discussing it.
So yeah, I agree. From what you're telling me, yes, they ought to take it into account. They can increase your rates when there's a building order on your home. The question is to what extent.
Okay.
Right.
Okay.
Cool.
So have a look, and I suppose my starting point would be, do I think the value on my rate notice is wrong, even taking account of the building order?
Yeah.
If you do, then that's the process.
Good luck, Fiona. Steve is in Rowville. What's your query, Steve?
How are you, mate?
Good.
I'm just ringing. My wife got pinged sneaking through a red light and incurred a $600 fine, but 2 days after getting the fine, we're unaware of it. We travelled away to work in Western Australia.
Yes.
On coming, we had our mail forwarded on, but anyway, some of it got distracted on the way across. She put in for a first review. It's a company car to nominate a driver, and they've knocked it back and turned a $600 fine into a $7,000 fine.
I know there were some steps in the middle, Steve. It doesn't go straight from $600 to $7,000.
No, like I said, we were late in paying it because our mail was forwarded on late, because of where we were so remote. And then she put in for a first review stating with evidence of where we were and away and proof of that. And they've knocked it back. And she spent a whole day on the phone trying to get legal advice and ringing Fines Victoria. And they said there's no option, there's no chance of a second review.
And what about going to the Magistrates Court?
Well, I don't know. We haven't thought of that. Mandy rang several legal firms and rang the Ombudsman and a few mobs, and they said, no, we don't handle that sort of thing. So,
okay. Steve, can you listen next week? And Raf, what I'd like to do is, in a sense, run a few examples and point out where the cost structures change. So you appreciate the need to get someone else to read your mail, Steve?
Well, it's hard. Yeah. Well,
it was hard.
I'm hearing you.
Yeah. So next week I'll run through them. I'll take that as homework because so far I haven't got any, and we'll deal with how traffic camera and offences can just go crazy.
And a final brief one. Jeff's in Box Hill. What's your query, Jeff?
Hello?
Yeah, go for it.
Oh, hello. Thanks, David. Look, my wife and I own a flat in a block of 15. There's a management committee of 3. I'm the chairman of that. The block needs painting. It hasn't been done for 15 years or more. But the other 2 people on the committee don't agree. They won't do it. And so it seems to me silly that 2 people out of 15...
You mean 2 people who don't agree? It's 2 out of 3, Jeff. It's not 2 out of 15. If you want the block painted, then call a special general meeting for the purpose of considering your resolution to repaint the block at a cost of X.
Yes, okay. But let me say the problem with that is that at our annual general meetings, and I fear it might be the same at a special general meeting, hardly anyone comes. Last time there were only 2 people there.
Okay.
You've got to ring them all.
Looking for proxies then, Jeff.
Yeah.
Right.
Can I ask the body corporate manager to give me the names and addresses and phone numbers of all the other owners? Is that
the answer to that question is yes. It's really interesting. I get a whole lot of people who ask whether or not an owner is entitled to know who the other owners are. And if you look at the Owners Corporation Act, the Owners Corporation is required to keep certain information in respect of each owner in a register, and every other owner is entitled to look at the register. Just Owners Corporation managers don't like sharing.
But you are entitled to get access to the info.
Yes, you are.
Okay. Good luck, Jeff. You'll need to convene some sort of special meeting. David Whiting, thank you very much.
Pleasure.
One little bit of homework there with Steve from Rowville.